Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. Today, reports surfaced that the Trump administration is attempting to impose case completion quotas on immigration judges. Here to share what this would mean is Kelli Stump, chair of AILA's EOIR Liaison Committee. Kelli, thanks for joining me. What is the administration proposing?
So the new administration is proposing a case completion quota directly to the individual IJs, which will reflect upon their performance evaluations. So this is different. This has never been done before. In the past, we have, as practitioners, have seen where the individual courts will have their own specific goals for case completion. It's never been directly targeted at the individual IJs. So now it'll come out in their performance evaluations.
How would this harm the immigration court system?
So this is going to harm the immigration court system in several ways. In fact, I don't see how it's going to help it. The main problem that I see here is that it's going to strip our clients of their fundamental due process rights. The due process clause of the Constitution guarantees our clients a meaningful opportunity to have their immigration cases heard. So if an immigration judge now has a case completion quota and is going to have his or her performance evaluated on whether or not this quota is completed, how does that give our clients a meaningful opportunity to be heard? Additionally, this strips the immigration judge's own independence in how they handle their court dockets and how they decide their cases. So while yes, some cases can be completed fairly quickly, it's the immigration judge that's the expert on the matter and knows when a client needs a continuance and knows when a client needs more time on how to present his or her case.
What should be done instead?
Well, instead of focusing on mass deportations, the administration should reverse course and refrain from imposing this plan. There are already 600,000 cases backlogged across the country in the immigration courts, and that's in the non-detained setting. Implementing this plan of quotas is going to cause pressure on the immigration judges to decide cases quickly, thereby denying our clients their due process rights. Additionally, Congress should be conducting an oversight on the EOIR to ensure that due process rights are not violated. In fact, Attorney General Sessions is testifying next week, and I encourage senators to ask him questions and call on him to denounce this plan. But ultimately, we need legislation. We need legislation guaranteeing better court systems, whether it's more immigration judges, better filing procedures, but legislation is our ultimate goal to give us better courts and better guarantees of due process.
Thanks, Kelli, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.